something which has been spun out for the first time. So if you think, you hear the expression Raj Dharma bandied about. It was even yesterday or day before, there was a talk of Raj Dharma. I think even in the monarchical times in India, the kings and the subjects were governed by dharma, Raj Dharma or Dharma. And when the British came, they in fact made a law in the 18th century that wherever there are silences in the statutes or in the Hindu law or the Muslim law, then the courts would follow what they termed as justice, equity, and good conscience. That was the law enacted for the courts to follow, justice, equity, and good conscience. Is constitutional morality anything different from either this dharma or justice, equity, and good conscience? I would say no. This is a moral principle in regard to governance, administration, which is embedded in the true spirit of the Raj as has been in this country all along. Aberrations are always there, exceptions have always been there. But can that be today resurrected, as it were, as a kind of an implied limitation on legislative powers or executive powers? See, one of the founding fathers, Dr. Ambedkar, invoked the spirit of the Constitution. You know, we have had, in the earliest years of the Constitutional Code in 1951 and 52, in 51, the spirit of the Constitution was invoked in respect of the press freedom. This was in Keshav Madhavan case in 51 and was negative. This was again sought to be revived when after the constitutional amendment, first constitutional amendment, the land reform laws were made in various states, including Bihar, UP. And Dr. Ambedkar was appearing as a lawyer for some of the zamindars of Bihar whose lands had been taken over. And he said, they have a property right, notwithstanding the amendment to the Constitution, they are entitled to compensation, that is as per the spirit of the Constitution. And the Constitution bench negatived it. There is no such thing as a spirit of the Constitution which will be used to test the laws of the legislature. You will have to find it in the letter of the law, in the letter of the Constitution. If that is found, okay, this was one set of constitutional cases as they came up when we started as a nascent republic. The second set of cases that came up were in regard to public order. Anwar Ali Sarkar, where detention took place. There again, not spirit of the Constitution, but question was raised in regard to validity of laws, the reasonableness of the restriction which had been imposed. Question was raised also in regard to right of equality, equal access. Therefore, in those cases again, while interpreting Article 14 or Article 19 for the purpose of reasonable restriction, how would you say something is reasonable or not reasonable? The spirit was not invoked, but argument was raised based on due process. Due process was rejected. It was held by the Supreme Court. This was considered in the Constituent Assembly based on the American precedents, but it was not acceptable to the Constitution, to the Constitution makers, Constituent Assembly. Therefore, you can't invoke due process. But notwithstanding the rejection of due process clause, the court adopted the tests which were nothing but really the due process, because they adopted the test of just, fair and reasonable. Though of course the fundamental rights were treated as separate identified compartments. That was given up much later in Cooper and Menaka Gandhi and subsequently. But whether it was Vivian Bose or other judges, all of them started testing the validity of the laws against Article 14 and Article 19 on the basis of whether it is just, fair and reasonable. So this was a kind of interpretative process by which they imported this principle. Then we come to 1970s, where for the first time, perhaps rightly, an implied limitation was read in. Because at all other times, when the spirit or this just, fair and reasonable test was invoked, it was for testing executive action, except in regard to testing of some of the constitutional amendments where the court did not apply this. When in the late 60s, Mr. Nambiar for the first time raised this doctrine of implied limitation based on the Irish and German precedent. It was not accepted, though Justice Mudolkar refers to it. In the next case, Chief Justice Subbarao held an amendment to be a law within the meaning of Article 13, therefore it was not necessary for him to go into even this theory of implied limitation in Golaknath. So for the first time, when in Keshwananda Bharati, the argument which had been advanced almost 7-8 years earlier was revived by Palkiwala. The theory of implied limitations, basic structure theory, was applied because otherwise Article 368, the amending power of the Constitution, was not subjected to any restriction. Therefore, for testing the validity of a constitutional amendment, you invoke this either some kind of a spirit of the Constitution or an implied limitation, a basic structure theory, because you can't amend it out of existence. You can't make an amendment which will take away the basic character of the Constitution. There were two other occasions when this theory of constitutional morality was again urged before the Constitutional Bench. One was when the Privy Purse abolition case came up in '94. The other was the bearer bonds case. R.K. Garg, as a public interest litigant, had challenged the law which provided for some tax concessions, protection of persons who had violated tax laws by offering this bearer bonds. So the theory of morality was sought to be revived. This will be contrary to the morality, public morality, constitutional morality. And the abolition of privy purse, it was said, would mean there was a constitutional promise held out to the princess who joined the Indian Republic and gave up all the rights. Therefore, you are now taking that away, taking whatever you had assured them. Therefore, this will be a violation of constitutional morality. On both occasions, the Constitutional Bench rejected this theory and said that no, that is for the legislature to decide and it is not for the courts to decide. But strangely, in the last 3 years, you have had a number of cases which have invoked this doctrine of constitutional morality to test laws. And in one case, even to restrict the exercise of right by citizens of their fundamental right. We have the 3 cases which are, one is in regard to the powers of Delhi state, Delhi administration. There this doctrine was invoked. You have the Navtej Singh Johar's case where the decriminalization of homosexuality was considered. Then you have the Joseph Shine case in regard to adultery, whether that's discriminatory and violative of constitutional morality. You have these 3 sets of cases which are more for either testing the validity of the laws or for interpreting the laws. But in the Sabarimala case, you now have a case of competing fundamental rights, competing rights, one right of religion and another right of equal access, equality, where the right of faith and belief and right to religious practice of a set of people is sought to be abridged or restricted by invoking the doctrine of constitutional morality. Your right, your exercise of your right to religious belief and practice cannot be done in a manner which would really be in violation of what is considered as constitutional morality. Therefore, you have now seen this doctrine of spirit of the Constitution or doctrine of constitutional morality which was buried in the 50s and not allowed to be revived even in the 80s and 90s, now is given a breath of fresh air and resuscitated, not only to test laws, but I would say even to abridge through a judicial diktat, as it were, not through the process of legislation, by judicial diktat, judicial interpretation of the exercise of fundamental right by another set of people. I think this is broadly the canvas which I want to introduce. Thank you very much.
And then,